第三队向左走，第三队向右靠近，向前看，第三队小心。 残余队列立正。残余队列这里。备备。安首席法官，全體隊列列隊完畢，請你檢閱。 仪仗队，我走。仪仗队，起步走。全体队的敬礼。立正。首席法官你好，請批准全體隊列經過檢閱台，向你致敬並且離場。儀仗隊，向右走。仪仗队，我走。仪仗队，起步走。加油！加！
歡迎莅臨法律年度開啟典禮，為免影響典禮進行，請將手提電話轉為靜音模式，並關掉其他響鬧或發光裝置。為確保典禮莊嚴有序，典禮過程中嚴禁拍照、錄音或錄影。多謝合作。Welcome to the ceremonial opening of legal year. To avoid disturbance during the ceremony, please set your mobile phone to silent mode and switch off other beeping or light-emitting devices. To maintain the solemnity of the ceremony, photo taking, audio or video recording is strictly prohibited during the ceremony. Thank you for your cooperation. 欢迎莅临法律年度开启典礼。为免影响典礼进行，请将手提电话转为静音模式，并关掉其他响闹或发光装置。为确保典礼庄严有序，典礼过程中严禁拍照、录音或录影。多谢合作。 主禮人士現在進場，請各位繼續就座。Please remain seated when the official party proceeds onto the stage. 主禮人士現在進場，請各位繼續就座。 現在準備就唱國歌，請各位肅立。Please stand solemnly for the playing and singing of the national anthem. 現在準備奏唱國歌，請各位肅立。請各位就座。Please be seated. 請各位就座。
Secretary for Justice, Chairman of the Bar, President of the Law Society, fellow judges, distinguished guests, ladies and gentlemen. On behalf of the Hong Kong judiciary, I extend a very warm welcome to all of you to the ceremonial opening of the legal year. This significant occasion serves as a timely reminder to our community of the vital role an independent judiciary plays in upholding justice and the rule of law. It also offers an opportunity to reaffirm the core values on which our legal and judicial institutions are founded. The judiciary's work over the course of 2025 is set out in detail in its annual report, published electronically today. In particular, I have provided an overview of the key areas of work undertaken during the past year in the welcome remarks. This allows me, in this year's speech, to devote attention, first, to some fundamental principles essential to the rule of law and judicial independence, which have been brought into focus by a recent case, before turning to another topic concerning the constitutional roles of the different branches of government in the protection of rights. The long criminal trial of Mr. Jimmy Lai and his companies before the Court of First Instance of the High Court has recently concluded, resulting in the convictions for national security and conspiracy offenses. Sentencing remains pending, and appeals may or may not be forthcoming. As expected, the outcome of this high-profile trial has attracted significant international attention and commentary. Also, as expected, given the prevailing geopolitical tensions, some of these responses have been critical, not only of the prosecution and verdicts, but also of the courts and the rule of law in Hong Kong generally. It is important to emphasize at the outset that the legal process remains ongoing. The defendants retains the rights to appeal. Any alleged errors, whether legal, procedural, or evidential, will be considered by the Court of Appeal should an appeal be lodged. For obvious reasons, I will not comment on the merits of the case or make categorical assertions about the proceedings. The appropriate forum for resolving any such issues remains the judicial process itself. However, I would like to take this opportunity to highlight a number of general matters of importance. To begin with, we fully respect the right of individuals to express their views. Few court decisions please everyone. Rather, the strength of our justice system lies in its adherence to the law and its openness to scrutiny. In this respect, it is no different from those in other developed common law jurisdictions. However, a comment or a criticism is only as meaningful as it is informed. Any serious comment or disagreement intended to be taken seriously must be grounded in a careful reading of the judgment and a sincere effort to understand the court's reasoning. Hong Kong's basic law and general laws, along with the national security laws, all guarantees the independence and impartiality of the courts and the right to a fair trial. They require that court decisions be based on the evidence and legal arguments presented, and not on extraneous considerations or public pressure. These fundamental principles govern all criminal proceedings in Hong Kong. Save for narrow and well-defined exceptions, all criminal trials are conducted in open court, in accordance with established rules of criminal procedure and evidence. Members of the public, as well as the press, are permitted to attend hearings without undue restrictions. Invariably, the prosecution bears the burden of proving the defendant's guilt beyond reasonable doubt. Both the prosecution and the defense are entitled to call witnesses, tender documentary and other forms of evidence, and make legal submissions. Unless they choose to represent themselves, all defendants are legally represented at trial, either by privately instructed lawyers or by those funded through the public purse. A defendant may, if they wish, give evidence in their own defense. If they choose not to do so, the prosecution may not comment on that fact, and certainly no adverse inference may be drawn from it to establish guilt. Unless the case is tried before a jury, all verdicts are accompanied by reasons. These typically explains the charges, summarize the prosecution's case and the defense, describes the evidence adduced, and set out the court's reasoning for its findings and conclusion. This transparent process, which is followed in all criminal trials with necessary adaptations where appropriate, ensures accountabilities and enables full and meaningful appellate review where required. At the risk of stating the obvious, it should be noted that court decisions are subject to appeal or review in accordance with the applicable procedures. I have every confidence that the Court of Appeal and ultimately the Court of Final Appeal will, as always, act with integrity and professionalism in handling any appeals or reviews. Under the Basic Law, the courts, as the judicial organ of the Hong Kong Special Administrative Region, are under a constitutional duty to hear and determine all cases that are properly brought before them. They concern themselves only with the law and the evidence, not with any underlying matters of politics, policies, or other non-legal considerations. As professionals, our judges take seriously the judicial oath to administer justice fairly and impartially. Any suggestion that a judge would compromise their conscience or integrity for political or other extraneous considerations when hearing a case is, by its very nature, a serious one that should not be made without cogent evidence. Bold and unsubstantiated allegations of this kind merely indicate that the criticisms may themselves be influenced by political or other extraneous considerations. As to sweeping comments on the state of the rule of law in Hong Kong, arising from the outcome of a particular case, many of us may be forgiven for growing weary of simplistic assertions that the rule of law is dead whenever a court reaches a result one finds unpalatable. The rule of law in Hong Kong is far more robust and enduring than the outcome of any single case. It cannot be that the rule of law is alive one day, dead the next, and resurrected on the third, depending on whether the government or another party happens to prevail in court on a particular day. Such a claim needs only to be stated to highlight how untenable it is. As regards calls that are sometimes heard to halt proceedings or prematurely release a defendant, based on reasons such as occupation, background, or political causes, it should be emphasized that such demands not only circumvent the legal procedures established to ensure accountability under the law, but also strike at the very heart of the rule of law itself. A foundational tenet of the rule of law is that no one is above the law, regardless of their status, occupation, office, political affiliation, personal belief or conviction, popularity, wealth, connection, or any other characteristic. The law applies equally to all, without fear or favor. Those who are genuinely committed to upholding the rule of law must also be committed to allowing the courts to do their work according to established legal processes and without interference. As to the threats of sanctions that have been made from time to time against our judges, it is clear that however these threats are framed, they are, in substance, attempts to interfere with judicial independence by means fundamentally at odds with the rule of law. Intimidation and threats are no different from bribery and corruption, they being, in truth, two sides of the same coin. Both are means of subverting justice and have absolutely no place in a civilized society governed by the rule of law. I will now turn to a different topic concerning the respective constitutional roles of the judiciary, the executive, and the legislature in the protection of rights. It is without doubt an important aspect of any constitutional framework. The Hong Kong Special Administrative Region is established by the Basic Law pursuant to Article 31 of the Constitution. In matters of fundamental rights, the Basic Law, along with the constitutionally entrenched Hong Kong Bill of Rights, provides a legal framework within which all public authorities must act. I will first start with the courts. Their constitutional function is to adjudicate independently, applying legal principles to the facts before them and making reasoned decisions. In the constitutional or public law case, where it is alleged that the government has breached or failed to protect a certain right, the court must carefully consider the claim by reference to the right asserted and any other related or competing rights or interests, the existing case law, the evidence adduced, and the justifications put forward in defense of the subject matter under challenge. If a case for breach is not made out, it is dismissed, usually with cause. If the case is established, the court must so hold and determine what remedies, if any, should be granted. In some instances, a legislative provision or administrative rule may be reinterpreted to eliminate the offending part where possible. Where that proves infeasible, the court may have to strike down the provision or rule altogether, rendering it of no further legal effect. In other cases, the court may simply grant a declaration, that is, a formal court statement of the legal position concerning the rights, obligations, or status of the parties or other relevant matters. In all cases, the court's decision must be accompanied by clear reasons. Parties and stakeholders alike, as well as the public, are entitled to understand how the law has been interpreted and applied. Courts exercise great care in granting legal remedies in constitutional and public law cases. Often, they leave room to the government to determine, in accordance with the rule of law and principles of good governance, how best to fulfill its constitutional or public law duties. Judicial restraint in this context reflects constitutional discipline and a recognition of institutional limits. Courts administer justice by applying the law. They seek neither to govern nor to legislate. In fashioning remedies, courts strive to uphold both the substance of the rights at issue and the proper division of constitutional functions. Before turning to the executive, it is important to say something about the finality of judgments on the interpretation of a provision in the Basic Law or of a right guaranteed by it. When the Court of Final Appeal gives judgment on such a matter, its interpretation represents the authoritative statement of the law, subject only to any interpretation by the Standing Committee of the National People's Congress, and then only in prescribed and exceptional circumstances. The court's interpretation binds all, the public, the administration, and the legislature, including individual members. This upholds the design of the Basic Law, which vests the power of final adjudication in the Court of Final Appeal. To say that an interpretation of the final court is binding on all is simply to recognize what the Basic Law expressly provides regarding final adjudication. Respecting the court's judgment is simply respecting the Basic Law. People are, of course, entitled to hold different views on controversial matters. They may also express disagreement with a judgment. But disagreement with a final judicial interpretation does not provide a legal basis to depart from it. The constitutional space for debate lies not in reopening a judicially concluded matter, but in determining how best to conform our system to what is protected under the Basic Law as finally interpreted by the court, taking into account all legitimate and relevant considerations. The responsibility for compliance and for taking remedial steps ordinarily rests with the executive. Naturally, most decisions that give rise to constitutional or public law challenges, whether concerning welfare, immigration, taxation, or public administration, are executive in nature. The executive operates the policies and systems that govern our society. It is typically the respondent in judicial review proceedings. And it has both the duty and the capacity to bring its policies and systems into compliance. Depending on the facts, remedial measures may involve revising administrative policies and guidelines, modifying existing systems and procedures, reallocation of resources, and where primary legislation is required, introducing a bill supported by policy reasons and where appropriate, public consultation. This duty flows directly from the rule of law and the constitutional imperative to uphold the basic law, including its protection of fundamental rights. The legislature, in turn, exercises a distinct and constitutionally protected role. Its members are elected to scrutinize, debate, and enact legislation. They do so under an oath to uphold the basic law. That oath establishes a constitutional framework, but does not dictate how members must vote in relation to individual bills. Courts are careful not to intrude upon the legislative process and fully respect the legislative discretion that the legislature enjoys. Some have sought to explain this judicial restraint by drawing comparisons with the United Kingdom, where Parliament is sovereign. It is in many ways a natural reference point, but not an equivalent model. In the United Kingdom, the Constitution is largely unwritten, political in nature, and crucially, Parliament is supreme. No court can strike down an act of Parliament. No institution, including the judiciary, has the authority to dictate what Parliament must or must not enact. The legal authority of Parliament is absolute, and its enactments are binding regardless of content. Hong Kong's constitutional order is different. Our constitutional framework is written and legal in nature. Our public authorities, including the legislature, exercise their powers under the Basic Law, which itself derives from the Constitution. The Basic Law defines the scope and limits of institutional authority. Within that framework, the courts are tasked with interpreting and applying the Basic Law with finality, subject to and within the legal parameters set by the Basic Law itself. It is for the executive to propose legislation where required, and for the Legislative Council to consider and enact it as it deems appropriate. In this way, our system preserves both constitutional discipline and space for legislative discretion. In practice, what emerges is a constitutional division of labor, with each branch of government operating within its constitutional role. Even on occasions when consensus between them proves elusive, at least for the time being, the system does not grant to a halt. The court's judgment stands as a vindication of the affected individual's rights and triggers the executive's duty of compliance under the law. As a result, incompatible administrative rules may fall away, and governmental policies and practices may evolve. New measures may emerge to alleviate the position. The resulting picture may not be perfect or seamless, but it reflects meaningful constitutional progress. And that, too, forms part of the constitutional model established under the Basic Law. By definition, controversial matters attract divergent views. Public confidence in the rule of law need not be affected by the presence of differing perspectives on these matters between the branches of government. Far more important is the respect each shows to the other and their respective constitutional roles, with each branch maintaining its role and a robust respect for the rule of law. We believe that even complex, multidimensional issues can in time be worked through with both principle and practicality. Last but by no means least, every one of us in the judiciary shares in the deep sorrow felt throughout our community in the wake of the tragic fire that occurred in Wangfuk Court in Tai Po last November. This horrific incident resulted in a devastating loss of life, inflicted great suffering on only too many families, and caused extensive damage to homes and property. As the community moves forward, our thoughts remain with those affected as they work to recover and rebuild in the aftermath of this tragedy, supported by many across our society. For its part, the judiciary has announced measures to expedite and prioritize legal proceedings arising from the tragic fire. A task group led by the Chief Judge of the High Court has been established to oversee handling of cases across all court levels. In addition, a support team has been set up to manage probate matters and liaise with relevant departments. Probate-related fees for deceased victims will be waived, with other fee concessions to be considered on a case-by-case basis. The judiciary will continue to draw on support from the legal profession as appropriate. It only remains for me to wish you and your families good health and a peaceful year ahead. Thank you.
Chief Justice, members of the Judiciary, Chairman of the Bar Association, President of the Law Society, distinguished guests, ladies and gentlemen, the ceremonial opening of the legal year is not merely a ceremony. It's a unique annual event for the judiciary to speak out on important issues and for representatives of the legal profession from both the public and private sectors to show our support to the judiciary and pay tribute to judges and judicial officers for their contributions. There's no question that in the past year, as is always the case, our judges and judicial officers have performed their duties conscientiously and professionally. But most of their work will be of interest to the parties directly involved in court proceedings only, and will not receive any public attention. Court news reported in the mass and social media were focused on a small number of cases, in particular, national security cases which were considered to be of public interest. Comments and discussions on these cases are generally permissible because of the freedom of expression and freedom of the press. However, these freedoms do not include making unfounded accusations against the integrity of our judiciary. It's disappointing and frustrating, though not entirely surprising, that the judiciary has been subject to such unfounded accusations due to judgment delivered in a number of highly charged national security cases last year and recently. Worse still, some of these accusations were misrepresented as facts and used as pretext to advocate imposing unlawful sanctions against judges involved in those cases, and to put illegitimate pressures on foreign non-permanent judges of the Court of Final Appeal to resign. One of the duties of the Secretary for Justice is to act as the guardian of public interest and the due administration of justice. This is why I feel obliged to take this opportunity to refute these unfounded accusations. This is extremely important because unless disabused, they may undermine people's trust and confidence in our judicial system and the rule of law in Hong Kong. Hong Kong's success as an international center in finance, trading, and other areas, as well as people's general sense of security, depend very much on the perception of and trust and confidence in our judiciary. Let me put things in context first. It is a fundamental principle of international law and international relations that every state has inherent and inalienable right to defend its national sovereignty and territorial integrity, and to choose its political, economic, social, and cultural system without interference in any form by another state. Very recent events in other parts of the world and recent statements made by some foreign politicians concerning the territorial integrity of other countries, including ours, sound a warning bell that it will be naive to assume that these principles will necessarily be followed. Concern over national security is anything but fanciful and must be taken seriously. Having said that, it is not and never the national policy of China to pursue absolute security. Under the relevant national law and the Safeguarding National Security Ordinance, national security is defined as a reference to the status in which the state's political regime, sovereignty, unity and territorial integrity, the welfare of the people, sustainable economic and social development, and other major interests of the state are relatively free from danger and internal or external threats, and the capacity to maintain a sustained status of security. I would like to emphasize the word relatively in the phrase relatively free from danger and internal or external threats. It does not say absolutely free from danger and internal or external threats. Our country clearly recognizes that it's essential to strike a balance between security and development. I explained in the white paper titled China's National Security in the New Era, released on the 12th of May last year. China strives to achieve a positive interaction between high-quality development and high-level security, and promote mutual reinforcement and coordinated enhancement between opening up and security. Not only that there's no conflict between safeguarding national security and promoting development of Hong Kong by ensuring that it remains an open, free, and diversified international city. Maintaining national security as defined under the law indeed provides the indispensable precondition for any development to take place in a safe, stable, and peaceful environment. Having regard to the significance of national security, Article 3 of the National Security Law, the NSL, imposes a constitutional duty on the executive, legislature, and judiciary of Hong Kong to effectively prevent, suppress, and impose punishment for any act or activity endangering national security. And I quote, in accordance with this law and other relevant laws. In the present context, it's pertinent to note the two following set of legal provisions, which prescribe the role of the judiciary and shed light on how it should discharge its constitutional duty in this respect. First, under Articles 2, 19, and detailed provisions in Section 4, Chapter 4 of the Basic Law, the judiciary is vested with and shall exercise independent judicial power, including that of final adjudication. Second, Articles 4 and 5 of the NSL provide respectively that human rights shall be respected and protected in safeguarding national security, and that the principle of the rule of law shall be adhered to, including, for example, no one shall be convicted and punished for an act which does not constitute an offense under the law. A person is presumed innocent until convicted by a judicial body. the right to defend himself or herself, and other rights in judicial proceedings that a criminal suspect, defendant, and other parties in judicial proceedings are entitled to under the law shall be protected. Having regard to these two sets of legal provisions, in national security cases, as in any other type of case, the court's duty is to conduct the proceedings fairly and properly, ensuring that human rights are respected and principles of the rule of law are followed, to construe and apply the relevant laws to the evidence, and then make its decision, all done independently. In considering the validity of any criticism that's been made against the courts in those highly charged national security cases, the correct question to ask is whether there's any ground to support that the courts have failed to discharge their duties as I have just described. There are a number of factors which can assist us to answer this question. First, it's important to observe what happened in the course of judicial proceedings, which were all held openly. Have the judges ever, without any good and sufficient legal reason, stopped the defendants from giving evidence or making submissions, or cross-examining the prosecution's witnesses? Has any of the judges made any inappropriate remarks indicating that they had bias or prejudice against the defendants? Did anything otherwise happen which would suggest that the defendants had not been treated fairly? I'm confident that any reasonable and objective person who has attended and observed those proceedings will answer all these questions in the negative. Some might opine that the proceedings have taken a long time. I would say the time was well spent and necessary to ensure that there was a fair trial to all parties concerned. Second, it's essential to study the judgments in those cases, which is indeed what people have been asked to do repeatedly. The judgments are of utmost importance because they explain how and why the judges came to their conclusions, and in criminal cases, why they were satisfied that the defendant's guilt had been proved beyond reasonable doubt. To be more specific, how they construed the relevant laws, what evidence and submissions they had considered, accepted, or rejected, and why, and how they applied the relevant laws as they understood in the light of the evidence and submissions which they had accepted. A sufficiently reasoned judgment also served another important purpose. That is to reassure people that the courts have not taken into account any irrelevant and improper considerations. Let me ask, in those national security cases, is there anything in the judgment which would suggest that the judges have taken into account any extraneous consideration, or that somehow their independence has been compromised? I'm again very confident that the answer must be a resounding no. Some people may wonder why the judgments are so long, running to hundreds of pages, and might even question whether they need to be so long, entailing long judgment writing time. The length of judgment is largely dictated by the amount of evidence and submissions heard and the complexity of the issues involved. In cases which were known to be controversial, the judges would naturally take great care to ensure that the judgments were sufficiently reasoned for reasons that I have just explained. Third, it's worthwhile to note that in national security cases, the government was not always the successful party. In the case involving many defendants, 2 defendants were acquitted after trial in May 2024, and the prosecution decided not to appeal against one of the acquittals. In March 2025, the Court of Final Appeal quashed the conviction of an offense under the implementation rules for the NSL. These incidents are an unequivocal evidence that the judiciary has been able to exercise and has in fact exercised independent judicial power in national security cases. As the unsuccessful party in those cases, the government would naturally be disappointed. If there were reasonable grounds to appeal, we would invite the appellate court to reconsider the matter. If the judgment was final, the government would review whether the outcome was caused by any deficiency or inadequacy in the relevant laws, and if so, would seek to amend the same. There's one critical point that I wish to add. On those occasions when the court ruled against the government, it would be unfair and incorrect to suspect, merely because of the outcome, that the court might have failed to appreciate the importance of safeguarding national security, and that they had not discharged their constitution. Fourth, in response to intimidation made against judges, the judiciary has reaffirmed in various statements in the past that all judges and judicial officers exercise judicial power independently and will continue to abide by the judicial oath and firmly discharge their duty in the administration of justice without any interference. There's absolutely no reason whatsoever to doubt the veracity of these statements. Enough is said about national security. It's important not to lose sight of the big picture that every year, the judiciary handles tens of thousands of civil and criminal cases of many different types, playing a key role in resolving disputes and maintaining the law and order of society. In some of these cases, particularly those decided by the Court of Final Appeal, the courts develop important common law jurisprudence, which makes significant contributions to not only Hong Kong, but also the common law world in general. An excellent example is that just 10 days ago, on the 9th of January, the Court of Final Appeal, in a scholarly and landmark judgment, held that it's appropriate to recognize the tort of harassment as a development of the common law in Hong Kong. However, a company cannot sue for harassment because it's incapable of suffering emotional stress, even though it may seek an injunction to restrain acts of harassment directed at its officers, agents, and lawyers. Apart from performing judicial duties, the judiciary has made tremendous efforts and contributions to promote the rule of law and enhance Hong Kong's status as an international legal service and dispute resolution center in other ways. On behalf of the Department of Justice, I would like to express my gratitude to members of the judiciary for taking part in the work of the Law Reform Commission, the Working Group on Mediation Regulatory System, and the Working Group on Arbitration Law Reform, as well as various capacity building programs organized by the Hong Kong International Legal Talent Training Academy. The rule of law, based on our common law system, is one of the most, if not the most distinctive and crucial advantage of Hong Kong under the principle of one country, two system. Members of the judiciary, the Department of Justice, the Bar Association, and the Law Society play different roles in our legal system. We may not and need not agree on each and every issue. In judicial proceedings involving the government sometimes succeeds, sometimes fails. But all that said, our solidarity, courage, and determination to maintain and enhance the rule of law in Hong Kong is unquestionable. Lastly, we are still in January, and the Chinese New Year, of course, will arrive in less than a month's time. So may I conclude by wishing you all a very happy New Year. Thank you very much.
Chief Justice, Secretary for Justice, President of the Law Society, judges, distinguished guests, ladies and gentlemen. On behalf of the Hong Kong Bar Association, I would like to extend a warm welcome to all of you at this ceremonial opening of the legal year. 2025 was another busy year for our courts and the administration of justice. I will deal with some developments relating to our top court. As our apex court, the Court of Final Appeal plays a pivotal role in the administration of justice in Hong Kong. To this end, Hong Kong is fortunate to be able to call upon the best judicial minds locally and from the rest of the common law world. In January last year, the term of office of Lord Hoffman as an overseas non-permanent judge was extended until early 2028. His lordship has been a strong supporter of the rule of law and judicial independence in Hong Kong since he started sitting in 1998. In the last summer, Sir William Young, an eminent jurist from New Zealand, was appointed as an overseas NPJ. Sir William served on the Supreme Court of New Zealand from 2010 to 2022. The Bar strongly believes that Hong Kong and its people greatly benefit from the present arrangement. Article 82 of the Basic Law provides that the CFA may, as required, invite judges from other common law jurisdictions to sit on the CFA. This was and remains an ingenious and very wise design, one which has enabled our final appellate court to benefit from the experience of top jurists in the common law world, and which has helped ensure that the court's decisions accord with generally accepted principles of the common law. Given the composition of the CFA, the development of the common law in Hong Kong will always be one which is appropriate for this jurisdiction and in line with its actual circumstances. The presence of overseas NPJs has a positive impact on the perception of our judiciary, both within and outside of Hong Kong. I will address this aspect shortly when I deal with the importance of perception and how in the real world, perception affects reality. One notes the proliferation of international commercial courts around the world. Many have spoken of the benefit of such institutions to the economy. This is consistent with the fact that many international financial centers are in common law jurisdictions. What Article 82 envisages and enables is far more remarkable. Rather than confine overseas judges to sit only in commercial cases, as if that were an area of law that stands separate from the rest of the legal system, our basic law enables overseas judges to assist in other areas of our law, including criminal law, constitutional, and administrative law. It is to the distinct advantage of the people of Hong Kong that our jurisprudence in all areas of legal can get input of eminent overseas jurists working together with world-class Hong Kong permanent judges in ensuring that the development of our common law is consistent with Hong Kong's unique circumstances. In terms of our permanent judges, it was announced in last September that Ms. Justice Ribeiro would be reappointed for a further term of 3 years from March this year. Mr. Justice Ribeiro's reappointment was universally supported by the legal professions, including members of the Bar. He has served on our top court since 2000, and his erudite judgments have been cited in many common law jurisdictions. It has been a matter of shared experience between counsel from both Hong Kong and overseas to find their carefully constructed arguments shown to be unsustainable after just 3 or 4 questions from his lordship. In terms of jurisprudence, the court has in the past year dealt with a wide range of significant legal matters, including the necessary ingredients to prove a conspiracy to defraud, the jurisdiction of a Hong Kong court to issue letters of request to a court in the mainland, the claim to public interest immunity and its impact on the right to a fair trial, which is essential, amongst other important legal issues. International litigating parties favor jurisdictions like the United Kingdom, Singapore, and Hong Kong to resolve their disputes. As Lord Burnett noted in a lecture he delivered in 2022, a study carried out by the English Ministry of Justice a decade ago concluded that one important factor that influenced the use of their courts by international parties was the reputation and experience of its judges. Reputation and experience are both consequences of the meritocratic basis for appointment from amongst the most experienced practitioners from the legal profession. Judicial independence is thus critical to protect fundamental rights and also for commerce. One of the key features which explains Hong Kong's great success as a seat of arbitration is not just the excellent arbitral institutions we have, the regular updating of the arbitration ordinance, but also the quality and independence of our courts. Arbitration does not exist in a vacuum. Applications to set aside awards and for leave to enforce awards are dealt with by the courts of the arbitral seat. And it is fundamental that these courts are and are seen to be both efficient and independent. In the recent report by the International Bar Association on the social and economic impact of the legal profession, the authors concluded that the strong relationship between the rule of law and economic growth is also backed by empirical evidence. The rule of law is strongly linked with GDP per capita across the globe. A 1-point increase in the rule of law index brings a 0.82% increase in GDP. By building and maintaining the rule of law, legal professionals help create the foundations for economic growth. The rule of law serves the economy, which in turn reinforces the rule of law. In the United Nations General Assembly's declaration of the high-level meeting on the rule of law, it was noted that the rule of law and development are strongly interrelated and mutually reinforcing, that the advancement of the rule of law at the national and international levels is essential for sustained and inclusive economic growth, sustainable development, the eradication of poverty and hunger, and the full realization of all human rights and fundamental freedoms, including the right to development, all of which, in turn, reinforce the rule of law. In summary, the stronger our rule of law, the more prosperous and the more resilient and stable our society will be. Lord Chief Justice Hewitt, in his judgment in the Queen and Sussex Justices ex parte McCarthy, famously held, it is not merely of some importance, but is of fundamental importance that justice should not only be done, but should be manifestly and undoubtedly seen to be done. This dictum is generally well known, if not amongst members of the public, certainly amongst lawyers and law students. Why does perception matter? It is obvious that if parties are reasonably left with a doubt about the impartiality of the court or tribunal, this will have an impact on confidence in its decision. The link between perceptions and reality is borne out by studies on sociology and human behavior. Mr. W.I. Thomas, an American sociologist, set forth a theorem in the field of social science to the effect that if men define situations are real, they are real in their consequences. This is in very broad sense akin to what is sometimes called a self-fulfilling prophecy. Other academics have looked at bank runs through the prism of the Thomas theorem, where rumors of insolvency, once believed by enough depositors, might result in the insolvency of a bank. But for the rumor, the bank would have operated just normally. In short, unlike hard sciences, the perception of the public on certain economic and societal matters affects their reality. Last year, my predecessor, Mr. Victor Dawes, SC, rightly highlighted the importance of how individuals and businesses perceive the exercise of rights by individuals and the state. It is important for all actors in Hong Kong to take into account this aspect of their decision-making on such perceptions, which may unwittingly and unintentionally impact on the reality. For its part, the Hong Kong Bar will continue to speak up on matters which relate to the rule of law, judicial independence, and the independence of the legal professions. This is in the Bar's objects and is in our DNA. The Bar is an independent legal profession made up of practitioners who operate independently. This, together with the cab rank rule, which exists only for barristers, explains why, despite our size, we have been able to punch above our weight. One example is our position on matters which relate to the constitutional right to legal representation under Article 35 of the Basic Law. Last year, we expressed our views concerning the amendment to the prison rules. We will also speak out here and abroad when our judiciary is unfairly criticized. This is the right thing to do. Mistaken perceptions regarding our judiciary are detrimental to Hong Kong's legal system and its people. As Mr. Kumar Ramanathan SC said at the opening of the legal year in 2013, the bar will actively participate in defending judges and the courts from unwarranted attacks. The reality today is that the judiciary is being targeted increasingly for specific case rulings. We have seen from recent events that this is relevant more than ever. The bar is confident that our judges are apolitical and will consider nothing except the law and the evidence. To criticize a ruling on the simple basis that one doesn't like the outcome is both unfair and does nothing to promote the rule of law. I would like to take this opportunity to thank two individuals who've served the Bar Council with dedication and will be taking what I hope is only a temporary but a well-deserved break. Mr. Derek Chan SC has not only been a high flyer in his criminal practice from day one, but also someone who has always served the bar and our legal system, both as a council member and as a vice chairman for 3 terms. I would also like to thank Mr. Eugene Yim, who has conscientiously served as our deputy and later secretary and treasurer for a combined 6-year term with dedication and fervent ardor for our values. But for the selfless dedication of many of our members, our mission would not be possible. It remains for me to wish everyone a healthy and happy year of the horse.
Good afternoon, Chief Justice, Secretary for Justice, Chairman of the Bar, members of the judiciary, members of the legal profession, distinguished guests, both local and overseas, ladies and gentlemen. Last year, at the opening of legal year, I spoke of a new era for our city and our profession. An era that calls on us to educate, to think big, to uphold our independence, to inspire, and to nurture talent. This year, I return to the same journey with a sharper focus: professionalism. The lodestar that sustains public confidence, trust, strengthens institutions, and enables Hong Kong to serve as a trusted bridge between China and the world. Professionalism begins with fidelity to our constitutional order and the rule of law, which includes judicial independence, due process, equality before the law, and recent adjudication. Under one country, 2 systems, Hong Kong remains China's only common law jurisdiction and the world's truly English-Chinese bilingual common law community. This is not just a dual heritage. It is our competitive edge, reflected in advocacy, cross-border transactions, disputes resolution, and the translation of complex standards across systems. Hong Kong's legal profession is recognized globally for its accepting standards and unwavering commitment to the rule of law and judicial independence. The basic law protects these bedrock principles with Article 85 enshrining judicial independence to ensure cases are decided by law, evidence, and proper procedure. As president of the Law Society, I am proud that for over a century, we have safeguarded professional standards through admission, practice regulation, and discipline, while nurturing talent and advancing access to justice, thereby sustaining public trust in our courts and outcomes. The practice of law is not merely a business. It is a public service rooted in the community's trust that justice will prevail. Our judges deserve our highest respect for their unwavering selfless commitment to adjudicate strictly in accordance with law, undeterred by unfounded criticism or external pressure. Day after day, they carry demanding caseloads, write carefully reasoned judgments, and uphold due process with impartiality and integrity. Rather than the executive or legislative branches, courts bear the ultimate responsibility for deciding cases according to law and proper procedure. That responsibility is discharged by judges who constantly put duty above self. As legal professionals, we must remember that the practice of law is a public service. Professionalism, manifested in integrity, objectivity, diligence, and respect, sustains the community's confidence in the administration of justice. Public service, not profit, defines our profession. Professionalism is not merely an aspiration. It is a concrete standard upheld by law and regulatory bodies. The Law Society's statutory role is to oversee the conduct of law firms and solicitors, maintaining the highest standards through rigorous admission, practice, and disciplinary processes. In the judgment of a solicitor and the Law Society of Hong Kong, the Court of Appeal reaffirmed Sir Thomas Bingham, Master of Roy's formulation in Bolton and Law Society that lawyers must discharge their duties with integrity, probity, and complete trustworthiness. And failures in this respect may warrant severe sanctions to protect the public and preserve confidence in the profession. The judgment emphasized that sanctions serve not as punishment, but to protect the public and uphold the profession's reputation, which outweighs individuals' interests. This case clearly underscores that professionalism and integrity are not optional. They are foundational to public trust and to the rule of law. History teaches that the true measure of a profession is revealed not in moments of ease, but in times of adversity. When our city faces uncertainty, when our institutions are tested, and when the rule of law is challenged, the public expects the legal profession to step forward, to lead, to defend, and to inspire confidence. In the heartbreaking typo fire at Rainfall Court last November, the Law Society mobilized at once, launching an emergency free legal helpline where volunteer solicitors provided guidance on personal injuries, wills and probate, insurance, civil litigation, and building management. We also set up on-site service counters across districts, enabling face-to-face support for families navigating laws and uncertainty. The quiet reliability of our members, including many young petitioners, exemplified professionalism under pressure. During our visit and tribute to the affected at the site, we witnessed citizens from all corners of Hong Kong queuing in solidarity, paying their respects with dignity and order, which was profoundly moving. It is a testament to the compassion and resilience that define our city. The orderly seeking of assistance by the unfortunate ones and the systemic support of the community strongly reflect that in times of adversity, the rule of law is a genuine safeguard of our society. Moments like this remind us, in the most challenging times, professionalism ensures the role of the legal profession is enshrined, so that the law is not only argued in courtrooms, but also brings clarity, support, and hope to communities in need. Our nation is embarking on a new chapter. The 4 plenary sessions of the 20th Central Committee of the Communist Party of China deliberated and adopted the recommendations for formulating the 15th Five-Year Plan, setting strategic plans for our country's development over the next 5 years. including important plans to support Hong Kong's development, painting a brighter future for our city. Under the recommendations, Hong Kong's strategic position has been defined to consolidate and enhance our status as an international financial, shipping, and trade center, and to build an international innovation and technology center. Our city is specifically called on to better leverage its role as a two-way opening bridge, fully strengthening its function as super connector and super value adder, so that it shall become a major channel hub for attracting external resources and a key platform for Chinese mainland enterprise to go global, thereby assisting the country's high-level opening up. This strategic reason aligns with commentary that urges Hong Kong to proactively connect with the 15th Five-Year Plan, embracing a hub plus engine role, connecting domestic and international markets, empowering innovation, and serving national modernization with new quality productive force, ranging from green finance and digital trade to smarter professional services. For our legal profession, professionalism ensures reforms are grounded in clear drafting, precise interpretation, and impartial administration. By upholding these standards, we reinforce institutional trust and sustain Hong Kong's roles as a beacon of Hong Kong excellence and a bridge between systems, contributing to the high-quality development envisioned in the 4 plenary sessions' recommendation for Hong Kong's long-term prosperity and stability. Professionalism also means preparedness, building resilient systems that protect the public, enable commerce, and responsibly harness technology. For over 35 years, our professional indemnity scheme has safeguarded both the profession and the public. Together with a robust anti-money laundering regulatory regime, we have proven the credibility of self-regulations that is essential to independence of the profession and the rule of law. The Law Society has prepared for the law tech and AI with foresight. As early as 2009, we introduced principles in the Hong Kong Solicitor Guide to Professional Conduct to govern the use of technology by solicitors, ensuring compliance with legal and ethical requirements. In 2024, we published a position paper on the impact of AI on the legal profession, highlighting the need for timely and proactive measures to guide AI adoptions for the benefit of our profession and the public. Most recently, we launched a brand new mobile application in last December, which represents a significant step forward in member engagement by offering a consolidated platform of features and services. Together, these initiatives reflect responsible innovation anchored in professional standards. While yearly indicators may shift, the long arc shows Hong Kong's legal system remains robust. The Real Justice Project Index placed Hong Kong high regionally and strong in absence of corruption and regulatory enforcement, reflecting the integrity in our systems and the diligence in our practice. These are not statistics to rest upon, but standards to surpass. As reforms advance and international ties deepen, professionalism will remain the currency that keeps trust high in courtrooms, in boardrooms, and across borders. As I draw this address to a close, it is my distinct honor to announce that the Law Society will soon embark on a new and momentous chapter with the opening of our new office premises in the second quarter of this year. Founded in 1907, the Law Society has walked alongside Hong Kong for 119 years, steadfastly committed to serving the public good and upholding the highest ideals of professionalism. In our long history, we have acquired our own premises only twice. First, in 1998, when our membership numbered around 4,500. And now, as we prepare to serve over 13,500 dedicated professionals. This relocation is not merely a change of address, but a reflection of our collective journey, our growth, and our enduring responsibility to the community. It is a humble milestone, reminding us that our true purpose lies in serving alongside Hong Kong, supporting its people, and advancing the rule of law for the benefit of all. Let us remember, professionalism is both our privilege and responsibility. It is how we sustain respect for our judges, whose selfless professionalism fortifies the rule of law, how we dignify our clients, and how we preserve trust of the public. It is also how Hong Kong's common law tradition contributes to China's modernization, advancing reform through law with integrity and confidence. May I wish you all a very happy New Year and good health. Thank you.
主禮人士即將離場，請各位繼續安坐，至主禮人士完全離場。Please remain seated until the whole official party has exited from the hall. 主禮人士即將離場，請各位繼續安坐，至主禮人士完全離場。